Hello, welcome to Introduction to Real Estate Law, Chapter 1. Glad to have you as part of the class, and we'll start talking here real soon about real estate law and what you'll learn through this course and how it applies to passing the real estate license exam and what you'll learn from the real estate law as we practice in Southern Ohio. We look forward to working with you and hope you'll enjoy the class. For this chapter, our learning objectives are to describe what can be considered property. When you think about property, what do you think about? Is it this piece of something that you can touch? Do you move it? Where does it go? What do you do with it? We'll also state the differences between real and personal property. We're going to talk about the bundle of rights relating to real property. When you have real property, it comes with a bundle of rights. There's things that you can do with it as far as your legal rights go. We're going to explain the sources of law governing real property. We're going to discuss how to legally resolve a real estate dispute. We're going to identify advantages and disadvantages of alternative dispute resolution. Why would you want to use alternative dispute resolution, ADR? When contracts call for it, what can you specifically do with it? And then we're going to recognize the differences between mediation and arbitration, because very often they're thought of to be the same, and they really are a little bit different. So, real estate in our economy, why is it important? Well, it makes up the biggest bundle of what is our GDP. Real estate contributes approximately 10% of the total output of the United States economy. But you've got to think about everything that's related to real estate. When we buy a house or we buy a building, or we move into an apartment, what are we going to do with that? We're going to buy things to go into it. When we own real estate, we have to make repairs. We're doing things all the time to our real estate. So those are all things that impact the economy, that add to the economy. And many of the parts of the economy are affected by real estate. We have a lot of different jobs that are impacted by the real estate market. And then we're going to talk about the health of the real estate market mirrors that of the American economy. Typically, as the American economy is growing, real estate is going well. And when we go through a recession, real estate will also go through that recession as a whole as the American economy. The nature of real property. There are two theories that define the nature of property. We have the natural rights doctrine. Again, think about what you learned in your civics class and history. We have certain individual rights that are inalienable. And then we also have the law doctrine, where property is created by government action. So we have those rights that are inherently inalienable rights, but then we have rights that are impacted by what government law does. Types of property. Property, anything that can be owned, possessed, controlled, divided, transferred, sold, and made available to others would be called property. We have two types of property. We have real property and personal property. Real property is the earth and all that is permanently attached and connected to the earth. And this is where we may see disputes when we're buying real estate, and things that happen is the personal property. Property is movable and not affixed or permanently attached to real estate. And there is some personal property that can become real property by how it's attached or by how it's designed. It's specifically designed for that particular window or something like that. Can make personal property become really part of the real property. We have tangible versus intangible property. Tangible is property interests that are those that exist in physical form. You can touch it, you can feel it. Intangible is property that lacks physical form. So that might be copyright or a patent or something like that. You've got to have something else attached to it, but that would be the intangible type of property. We have laws that are rights and duties. We have a legal right, the ability to have individual interests respected by others and enforced by the legal process. This is why we have attorneys and we go to court, because we want to have a legal process to determine what is right or what is fair. And law and fairness don't always go hand in hand, but the legal right. Then the other thing we have is a legal duty. It's the obligation imposed on an individual by either contract or applicable law. everything we do in real estate, when we're purchasing or listing or anything like that, there's a contract. it spells out duties of everybody involved in the contract. And then there's business law. There's laws that apply to how those are enforced. Those legal duties are enforced in those contracts. What's required of the buyer, the seller, the real estate agent, things like that. Those are things that we'll see examples of as we go through the course. We have a bundle of rights. When we buy or actually even lease a piece of property, we have something called ownership, the right to possess or transfer. But this piece about possession is 9/10 of the law. Yeah, who's living there, who owns it, who controls it, possession. The use, how we can use it. Can we use it for residential? Can we use it for commercial? Legal uses of property. It can be a brothel, or it can be, depending upon where it's actually located. The enjoyment, the right to enjoy our property, to have free use and enjoyment of it at all times. The right to encumber it. We can create liens, we can do easements, we can do other things, mortgages to encumber our property when we borrow on it. The right to dispose it. We can sell our property at any time. We can walk away from leases. There might be penalties, but at certain times it's done too. It comes to an end. And then we also have the exclusion of real estate. Who can we exclude? How do we use it? What do we do with it? So those are the bundle of rights. Sources of real estate law. We have a Constitution that creates a lot of our law. We have the Fifth Amendment. The federal government may not deprive any person of property without due process of law, which is the right to protest the government's claim, and clear statement of issues before a hearing. So this is the due process, our legal process. We also have something called the 14th Amendment. Two sections that are applicable to real estate property are equal protection clauses, the equal right to have access. Fair housing comes into this, creditworthiness, things like that. And then the due process clause, how we go about finding out whether there's issues or problems and how we resolve those. Sources of law. We have federal statutes. We have federal administrative regulations that come from agencies. We have state constitutions. We have state statutes, such as the Uniform Commercial Code, UCC, for the fixtures, things in the real estate. We have other state administrative regulations, again, organizations, the Realtor Board of the Division of Real Estate, things that can set administrative regulations or rules. We have municipal statutes and ordinances, such as our zoning and building codes. And then we have contractual agreements, what we actually write and present to each other. And a lot of our real estate contracts are basic business law, except they pertain to the real estate. An overview of the U.S. legal system. We have something called common law. It's non-statutory theories developed by courts covering legal relief for one person against another. This common law goes back to English society and how America was formed, things that we expect as some kind of norm in what we do. We have something called stare decisis. It's a legal principle that requires a court to apply prior appellate case holdings as precedent bindings on the court. So a lot of what we do and try in our court is based on precedent. There's some other kind of legal decision that has happened. Those legal decisions can change. We can get precedents that change. Some of that might be revolving around eminent domain. It used to be you could do eminent domain. And recently, a couple years ago, we had a case in Norwood that changed eminent domain and how we're going to proceed with eminent domain in the future with developing real estate and taking real estate. Then we also have something called adjudication, which is the legal process of resolving a dispute, going through that whole process. Again, jurisdiction, the authority of a court or agency to make legal determination over the person or property of another. We have federal jurisdiction, we have state jurisdiction, we have municipal jurisdiction. Where is your court hearing held? Where is the case heard, the law actually going to be adjudicated? And then we have types, in personam jurisdiction and in rem jurisdiction. The state court system. Most real property laws are created by the state, therefore most disputes are resolved through the state court system. And it's because of where the property lies. It lies within the state. Now, where it may become something federal is where it impacts a class of people or where you have people from different states that are arguing over something. But for the most part, anytime you have a real estate dispute, it will be held in the state's court system. The federal court system. We have federal questions jurisdiction, a case arising under the U.S. Constitution, treaties, or federal statutes or regulations. Again, that's where something might appear to be a state issue because it's real estate founded, but it could become a federal court issue. And then we have diversity of citizenship jurisdiction, a case where the amount and controversy exceeds $75,000 and all parties to litigations are citizens of different states. Then obviously it doesn't stay in the state. It's going to flow to the federal courts to be heard. U.S. Supreme Court. A partial, they're a party that's formally petitioned the Supreme Court through a petition of certiorari. There's a writ of this. The writ issued, the Supreme Court will review the decision of a lower court. If the writ is not denied, the decision of a lower court remains in effect. And if you listen to NPR or some of the news stations, you'll hear about cases where people are trying to go to the Supreme Court, and then all of a sudden they can't go to the Supreme Court. The Supreme Court says, no, sorry, we're not going to hear it. We're going to stick with the lower court's ruling. So those things do happen. The idea of trying to get something to be heard before the U.S. Supreme Court is the ultimate goal of attorneys, but it's not always practical. It doesn't always happen. It's not always required. The venue, the place where a particular case should be filed or administered by the courts. Again, this will be up to an attorney when you seek their advice where to actually file to hear our cases. And every state has rules that determine the proper venue for the different types of lawsuits. We have something called a statute of limitations, the maximum legal period which a legal proceeding may be initiated, measured from the date of the occurrence of the event giving rise to the right to pursue the legal claim. So again, statute of limitations. After time, it's no longer applicable. It's no longer going to be heard. And things can be expunged or removed from your history after so much time, too. Alternative dispute resolution. It's called ADR. It's a non-judicial process that seeks to resolve disputes between parties. And the different types of this ADR would be mediation and arbitration. Mediation is an informal process by which a neutral person, the mediator, assists the parties in reaching a voluntary, negotiated resolution of a dispute. They'll sit around a table, they'll argue back and forth, they'll present their issues, they'll present their concerns, and again, the mediator is trying to get everybody to reach voluntary decision as to how a dispute can be resolved. Arbitration occurs only upon the agreement of both parties. Disputes are resolved by a neutral third party appointed by the parties to make the final determination. And it can be binding or non-binding. My real estate contracts, when I manage real estate in a professional and commercial environment, a lot of them say that a court may be heard through arbitration and it will be binding based on the decision. So very often, this whole thing of whether you can do ADR will be actually covered in the contract. It states beforehand that ADR is a recommended way to hear the case. And that is it. Very simple, quick introduction about real estate law. You'll read a whole lot more. But again, this is the overview of real estate law, why we have law, what happens, where it occurs, and then as we go through the textbook, we'll get much more in detail about specific pieces of the different things that we've just covered in this overview. It was a pleasure talking with you today, and I look forward to going on with this class. Thank you so much.